Hello, bonjour, buongiorno, здравствуйте, buenos dias. Greetings from London, UK. Welcome to Laura Devine Immigration's presentation on the changes to EU nationals working in the UK following the UK's withdrawal from the EU. My name is Nicolette Bostock. I'm a senior solicitor at Laura Devine Immigration, a leading immigration law practice with offices in the UK and in New York, and I'm delighted to share this information with you today. To start off, I thought a quick visual guide to the changes which have taken place would be helpful. This timeline sets out the key dates and events which have taken place and are due to take place in the coming months, as relevant to the UK's withdrawal from the EU. You will most likely all remember that the UK voted to leave the EU in June 2016, and in preparation for the UK leaving the EU, the UK government, that is specifically the UK government agency responsible for Home Affairs called the Home Office, introduced a new immigration category to our domestic immigration regime, and this is called the EU Settlement Scheme, or EUSS for short, under which EEA and Swiss nationals and their family members in the UK could apply for permission recognising their continuous lawful stay in the UK and permanent residence if they are already eligible or acquired it. And this gives them status under our domestic immigration laws beyond Brexit. The EUSS opened fully to all eligible EEA and Swiss nationals and their family members in March 2019 and is still running today. On the 31st of January 2020 at 11 p.m. GMT, the UK ceased to be a member of the EU. However, for EEA and Swiss nationals and their family members, free movement was effectively still in place right up to the 31st of December 2020 at 11 p.m. GMT. The period between the UK ceasing to be an EU member and the end of free movement is called the transition period. Today, we are in a period called the grace period, which started on the 1st of January 2021 and it ends on the 30th of June 2021 at 11 p.m. GMT. You will note that 30th of June 2021 is also the deadline for EEA and Swiss nationals to apply under the EUSS. A new immigration system was put into place by the Home Office to accommodate EEA and Swiss nationals and their family members arriving in the UK from the 1st of January 2021 onwards. And now I'll expand on these a little further. So this is a quick recap in writing of the timeline I've shown you previously. The key points I would like to reiterate are: free movement continued until the 31st of December 2020. There is a 30th of June 2021 deadline for EUSS applications from EEA and Swiss nationals who were in the UK under free movement rules during the transition period, which ended on the 31st of December 2020. Eligible applicants can apply under the EUSS right away and up to the 30th of June 2021. In other words, by the end of the grace period. The alternative is that they apply for permission under the new immigration system. They must show physical presence in the UK within 6 months of the date of application and no later than the 31st of December 2021. Qualifying family members can join the EEA or Swiss nationals later under the EUSS scheme if they are outside the UK. Those who are in the UK may already be eligible to apply if they're in the UK and were here by the 31st of December 2020. It is important that individuals apply under the EUSS as soon as possible. We are seeing at the moment long processing times, and the legal status of any individuals who are in the UK during the grace period who haven't secured status is unclear, particularly if their applications are not decided before 1st of July 2021, which is when the grace period comes to an end and the normal immigration regime for all EEA citizens who don't yet have status in the UK will come into effect. So I wanted to go through the general eligibility requirements for the EUSS. Well, first of all, you need to have an EEA or a Swiss national, but EUSS applicants can also include direct family members of a qualifying EEA or Swiss national, or even the extended family members, provided that they get a permit prior to arrival in the UK. It is absolutely mandatory that the EEA or Swiss national held their EEA or Swiss nationality and entered the UK by 11 p.m. GMT on the 31st of December 2020. Now, if you've got an EEA or Swiss national or a family member who's already completed 5 years of continuous residence in the UK, or they have already been issued a document confirming permanent residence in the UK, they can apply directly for a status called settled status, which is indefinite leave to enter or to remain in the UK. And they need to show that they haven't lost or broken their indefinite leave to remain or settlement in the UK through a period of extended absence. In addition, any individuals who do not meet the requirements for settled status based on 5 years of continuous residence in the UK can apply for 5 years of immigration permission. This is time limited and the end date will be set at 5 years from the date on which it's granted, and this status is called pre-settled status. It eventually leads to settled status if the individual completes their 5 years of qualifying residence. In order to make either of these applications, there must not be any serious criminality, any deportation, or removal instructions from the UK in place for the applicant. In addition, each applicant must not have been absent from the UK for more than 6 months, where they're applying for pre-settled status or settled status, since arrival or per year of the qualifying residence period. There are very limited exceptions to this, and so it will be generally quite strictly applied. As mentioned before, they need to apply by the 30th of June 2021, but there isn't a deadline for settled status applications where an individual is eligible to apply. The procedure should be fairly simple by comparison with many other visa application routes. First of all, an EEA or Swiss national checks their ID using an app on their smartphone or device, and usually the chip in the e-passport or in the national ID card is read. If there is no suitable document through which the ID can be verified, then the individual needs to book an appointment to provide their passport or identity document as proof of who is the applicant. Once that stage is complete, then the individual will be directed to an online application form and then can upload evidence of their residence in the UK, and if they're a family member, their relationship to the qualifying EEA or Swiss national. The documentation that's issued under the EUSS is entirely electronic. That means that an EEA or Swiss national will be issued an email confirmation of the decision by the Home Office, and then they can verify their status online using a secure link and share their status with others as required. The only exception to this is where you have a non-EEA or Swiss national family member who's applying for the first time and is granted immigration permission for the first time, in which case they'll be issued with a biometric residence card to facilitate their entry to the UK. One of the great things about the EU settlement scheme is that there are no restrictions on work, study, and other activities in the UK. Therefore, once an individual has status under the EUSS, it will feel very similar to the rights that could have been enjoyed under EU free movement in the UK. Digging a little deeper now into family members, I thought it'd be helpful to show you that there is a difference between direct and extended family members. I've put the degree of relationship for direct family members in green and the degree of relationship for extended family members in blue. And those are a little technical and complex, but direct family members are usually quite straightforward. As you'll see, we have spouses and recognised partners, children, grandchildren and great-grandchildren under 21 years old, or of the spouse of the EA national or of their spouse or recognised partner, dependent children aged 21 years or older, where there is dependence on the EA or Swiss national or of their spouse or partner, dependent parents, grandparents or great-grandparents, and those of the partner of an EA national. And as you'll see, dependency is required here, and usually this means financial dependence. In addition, durable partners may also apply, and that's where typically individuals have been cohabiting in a relationship, in a serious committed relationship with one another, and they have amassed 2 years of cohabitation prior to the end of the transition period, 31st of December 2020. It may be possible to have variations from the 2 years cohabitation, for example, where the couple have children together, and it can be shown that the relationship's durable in other ways. Extended family members can apply where there's a retained right of residence. That's typically where there's been a divorce between the relevant EEA national, Swiss national, and the applicant, and the marriage is terminated, or indeed death of the EA national or Swiss national. There are certain types of derivative rights holders that have rights of residence under EU case law. Other relatives receiving personal care from an EA or Swiss national. And finally, other extended relatives, dependent aunts, uncles, nieces and nephews. If the individuals in the UK by the 31st of December 2020 with an EEA or EUSS family permit or other permission except as a visitor, they can apply directly under the EUSS by the 30th of June 2021 from within the UK. Now we're going to distinguish this with individuals who are outside the UK and are family members of an EEA or Swiss national at the date that they want to come into the UK. So direct family members who are outside the UK can apply directly under the EUSS if they hold indefinite leave to remain or a permanent residence document or a biometric residence card as a family member of an EA or Swiss national. If they are outside the UK and they don't have a relevant document but need one to come in, it is possible to apply for a document called a family permit. And this will facilitate the travel into the UK and ensure they're admitted in a category other than as a visitor, which is a prerequisite for being able to apply for pre-settled or settled status on the basis of being in the UK. This now includes durable partners who can apply for EUSS family permits from outside the UK. Extended family members who are outside the UK must obtain a document called an EEA family permit prior to travel, and then once they're in the UK, they can apply for pre-settled status. They will need to show that the family relationship started by the 31st of December 2020, that the EA and Swiss national that's sponsoring them was in the UK by the 31st of December 2020, and that their residence had not been broken by 6 months or more absence at any point during the start of their qualifying residence until the 31st of December. And in addition, that the EA or Swiss national has permanent residence or indefinite leave to remain, or was still within the grace period. That means they have until the 30th of June to apply, and it will be deemed that they can make an application within that time. And that all other mandatory requirements are satisfied, such as with regard to criminality and the degree of relationship. This does not apply to other relatives, such as dependent aunts, uncles, nieces and nephews, who must have been in the UK before the 31st of December 2020 to be eligible to apply under the EUSS. Now, I have mentioned on many occasions during this presentation so far that there is a 30th of June 2021 deadline. However, there are some exceptions to this, and I'll just recap on those now. First of all, family members with an EUSS family permit must apply under the EUSS within 3 months of the date of their arrival, if they're arriving from the 1st of April 2021 onwards. So that means that an individual with an EUSS family permit who's arriving after the 30th of June has 3 months from the date of their arrival in the UK, and that 30th of June deadline doesn't apply. Family members of British citizens who are returning to the UK from the EEA or Switzerland under Surinder Singh provisions, they have a deadline of 29th of March 2022 for close family members, but they need to show that the relationship with the British citizen started by the 1st of February 2020. So note, this is from the first day that the UK ceased to be a member of the EU, or at any point if the applicant is a child who could have been born after this date. Spouses and children of Swiss nationals with pre-settled status can apply by the 31st of December 2025. So this is a special provision in place specifically for Swiss nationals and their family members. And the relationship had no deadline. It could have started at any time by the date of application. Family members who have immigration permission under the UK's immigration rules under a different category, not the EUSS, they can apply before their immigration permission expires, including after the 30th of June 2021. The one exception to this is individuals who are in the UK as a visitor. Finally, individuals who are exempt from immigration control, for example, on a diplomatic basis, they can apply within 90 days from their exemption from immigration control ending. It is possible to apply under the EUSS later than the 30th of June 2021 where there are specific reasons that can be shown outside of the applicant's control for a delay in being able to make the application. Now, there is an open-ended list of examples, but examples given by the Home Office include hospitalisation or incapacity, which is particularly critical in these days of the coronavirus pandemic, or for having had a child or being pregnant overseas. And the Home Office accepts that it is a reasonable reason for delay. Once an individual is granted pre-settled status, they're typically eligible for settled status after 5 years of continuous residence in the UK, but they should be aware that absences can break this, and it's typically absences greater than 6 months over the 5-year period. No extension of pre-settled status can be given after the 30th of June 2021. Settled status. Individuals must not be absent from the UK for greater than 6 months in any 12-month period. Note that a single absence of up to 12 months only could be permitted for an important reason such as military service, pregnancy or childbirth overseas, study or posting overseas by a UK employer. Note that evidence of this will need to be retained and produced with the relevant application. Permanent residence and settled status can be lost if the individual is absent for a period of 5 years or more without returning to the UK. It may be possible to naturalise as a British citizen once an individual has been granted settled status and has held that status for 12 months or more. It could be possible for that 12-month waiting period to be reduced or waived if the applicant can show in their naturalisation application that had they made an application under the EU free movement laws for permanent residence documentation, it would have been granted before the 12-month period had started, so 12 months before the start of settled status. I'm just going to move on to a really interesting and new area of the UK's immigration rules linked to the EUSS for frontier workers. Now, this was introduced in early December 2020 to accommodate EEA and Swiss nationals who have been working in the UK or who are working in the UK but live elsewhere, noting that it is prerequisite for this route that they're not primarily resident in the UK. This is an application made by an individual, and it is not made by an employer, nor does it require any employer input or sponsorship. In addition, it's not tied to a particular job or role. Therefore, the individual, if they're granted frontier worker status, they can change jobs after the status has been granted. Another upside of this particular type of permission is that partners and children can apply for a permit to accompany the worker to the UK. The eligibility requirements must have been met by the end of the transition period, 31st of December 2020. Those are, there is an EEA or Swiss national, and that is the primary applicant. They were not primarily resident in the UK, and they were either a worker, self-employed, or an individual has retained worker or self-employed status in the UK, who was working regularly in the UK prior to the 31st of December 2020, but isn't in work necessarily at the date of application. They cannot apply under this route if they started work in the UK after the 31st of December 2020. The process and conditions are also really favourable for a frontier worker permit. Applications are free of charge. An individual can apply either under the ID check or online using an app, but they may not be able to use the app if there is an absence of a biometric passport. That's a requirement for the app to be able to read the e-chip inside a passport to obtain the biometric data in order to fast track this element of the application using the app. As with EUSS status, successful applicants are issued with a digital permit entirely electronically via email and through an online link. If they didn't use the app, then they could be issued a physical permit to be able to enter the UK in the form of a biometric residence card or a sticker in the passport. The permit will be valid for 5 years, and this is in a single grant. If they are applying on the basis of having retained worker or self-employed status, having previously worked in the UK but before the 31st of December 2020, but not being in work at the date of application, then they'll get 2 years worth of status in the UK as a frontier worker. This can be renewed indefinitely. But note, a critical distinction from the EUSS is that it does not lead to settlement. Finally, just to restate and dig a little deeper into the residence requirement, the individual must not permanently reside in the UK. That means that they must have been in the UK for fewer than 180 days in total over any rolling 12-month period. Now I'm going to address the new UK immigration system and some of the areas that may be of interest both to EEA and Swiss nationals, but also to non-EEA and Swiss nationals who are seeking to come to the UK. So first of all, the new immigration system commenced its rollout in October 2020 and was fully rolled out by December 2020, ahead of the end of the transition period for EEA nationals and the end of free movement in the UK on the 31st of December 2020. It's an alternative route under which EEA and Swiss nationals and their family members can apply for status in the UK if they're not eligible under the EU settlement scheme that was covered earlier in this presentation. Those who are in the UK with rights protected by the grace period may apply from within the UK, otherwise all applicants need to enter from overseas. An individual can apply from within the UK where they have immigration permission under a category of the UK's immigration rules, excluding the visitor category. Most of the routes under the new immigration system mirror routes under the old immigration system. We have skilled worker for sponsored workers, formerly known as Tier 2 General, intra-company transfer for intra-group transfers of employees employed overseas by a linked entity or branch to a UK entity, and that was previously called Tier 2 Intra-Company Transfer. There's also sole representative of an overseas business for individuals who are seeking to come and set up a UK business where there is an overseas parent, and that is for managers who are coming to the UK as the first individual responsible for both incorporating and setting up and starting trading in the UK. For individuals who are able to invest £2 million or equivalent in UK actively trading companies in the form of shares or corporate bonds, then the innovator route may be of interest. Matt, if you could edit the previous bit out, then that would be great because there was an error here. I'll just give it 5 seconds. I'd like now to cover the new UK immigration system. This may be of interest not only to EEA and Swiss nationals, but also to non-EEA and Swiss nationals who are looking to come to the UK for work and residence in the UK, and where the EU settlement scheme is not available. Individuals who are in the UK with rights protected by the grace period may apply from within the UK, or in addition, if they have immigration permission under another area of the immigration rules, under the old system, for example, then they can apply within the UK. In all other cases, including where an individual's in the UK as a visitor, they must apply from overseas to enter the UK. Most routes under the new immigration system mirror routes in the previous system. We have skilled worker now, which is a rebrand of the former Tier 2 General category for skilled workers, including new hires. Intra-company transfer, which replaces the Tier 2 intra-company transfer route with a very similar name, and that's for qualifying employees of overseas entities which are linked by common control or ownership to a UK entity. Sole representative of an overseas business for managers or directors of an overseas business who are coming up to set up a UK subsidiary or branch of an overseas business before it starts trading in the UK. The innovator and startup categories are for entrepreneurs who are seeking to set up a viable, genuine, scalable and innovative business in the UK and have capital and speak English and are able to do that. And finally, we've got the Tier 5 International Agreement route, which replaces Tier 5 Temporary Worker. And this includes the mobility provisions of the EU and Swiss trade agreements with the UK, including for contractual service providers and independent professionals. Looking at the skilled worker route, this route is for individuals who are able to work for a UK entity with a skilled sponsor license already in place. This is a points-based category, and therefore, in order for an individual to be granted a visa under this route, they must obtain 70 points for various attributes, and this includes some attributes which have tradable elements. They must be assigned a valid certificate of sponsorship by the UK sponsor. The role must be a genuine vacancy and skilled to at least A-level standard, also known as RQF Level 3 skill level. The minimum salary for the UK role, which must be paid to the sponsored worker, must be the higher of either £25,600 per year gross as a basic salary, or the going rate for the type of occupation, and this is set in something called the Standard Occupation Codes, which have been incorporated into the UK's immigration rules. Skilled worker applicants must meet a minimum level of proficiency of English language, and that is set at level B1 of the CEFR. Maintenance requirements also are in place, and applicants must show £1,270 for the main applicant and additional sums for each dependent, or the sponsor can certify this in the certificate of sponsorship. It is possible now to switch in-country from various other immigration routes, except as a visitor, short-term student, and a few other categories. I'm glad to say that one benefit of the new system is that there is no resident labour market test advertising requirement. It's not a requirement for sponsors to show that they could have sponsored a settled worker or a British citizen in the role in preference to an overseas national. There's no cap on numbers or the total time in the route, and that's yet another benefit to the new system, whereas under the previous Tier 2 general route, it was a requirement to request a certificate of sponsorship from a monthly cap for any applicants who were based outside of the UK and seeking to come into the UK to work. This route leads to settlement, much like the EUSS, after 5 years of continuous residence in the UK. And in addition, partners and children can accompany the main applicant to the UK, and they can settle after 5 years of continuous residence also. Looking at the intra-company routes, there are two key sub-routes. The first is intra-company transfer, and the second is graduate trainee. It does require that there is a UK employer with an intra-company sponsor license in place, and that license must have had the overseas entities included under it, from which an employee seeking to come to the UK under the intra-company routes has been employed for the minimum qualifying employment period prior to the date of their application. The minimum qualifying period for an intra-company transfer is 12 months of previous employment with the overseas group entity. That's reduced for graduate trainees. There is an exception where the salary is £73,900 or above per year, in which case there is no minimum qualifying period of employment required. It has the same in-country switching rules as a skilled worker, and in addition, it is now possible to switch from intra-company transfer to skilled worker within the UK, and there's no cooling off period involved in that. There is also no minimum English language requirement to apply under intra-company transfer, which could be of great interest, particularly with European employees where the transferees don't speak English and it's not required to do the job. One downside to this route, and something that may cause employers to pause before they use it, is that time spent in intra-company transfer routes does not lead to settlement to the UK, nor can it be added to time spent in any other category towards the qualifying period for settlement. In effect, if someone has ICT leave and they switch into skilled worker, they'll be restarting the qualifying period for indefinite leave, effectively, from the date on which they become a skilled worker. The maximum period of time that anybody can spend in the intra-company route is 5 years in any 6-year period, or 9 years in any 10-year period if the salary is at least $73,900 per year. Looking at right to work, the Home Office has been producing guidance on employers' right to work obligations and how to document that a right to work check has been undertaken and the records retained appropriately for many years. The guidance was last updated in January 2021, and it confirms that EEA and Swiss nationals are protected by the grace period, and they can rely on valid passports and ID cards for right-to-work checks until the 30th of June 2021. UK employers cannot force prospective employees to provide evidence of their status under the EUSS, and retrospective checks are not required for any employees who are already employed by a business before the 30th of June 2021. New guidance is expected from the 1st of July 2021, and that will be to account for the new right to work checks which will need to be undertaken on any non-UK national to confirm that the employee, or new starter in these cases, does have the right to work in the UK. There is a ground for criminal liability for any employer or manager in a business who is aware of or has reasonable cause to believe that an employee is disqualified from employment by virtue of their immigration status. So even though today it's not a requirement for EU nationals and Swiss nationals to produce evidence of their immigration status in the UK, and it won't be until you have new starters from the 1st of July 2021, it's important to exercise caution here because the right to work obligations don't necessarily match the criminal liability for an immigration offence. Before the 1st of July 2021, it would also be prudent, avoiding any grounds for discrimination, of course, to just draw employees' attention to the EUSS, its existence, and the deadlines to ensure that where an employee is eligible, that they are making an application in time. Looking now at visitors, because this is an area that we get lots of questions about very, very frequently, every day, and are getting more questions about now from employers of EU citizens where they were previously able to enjoy free movement rights to the UK. The first thing to note is that visitors to the UK are permitted to undertake general business activities, and I'll come to those in a moment, but critically, whatever activities they undertake in the UK must not amount to work or taking employment or self-employment in the UK. And visitors to the UK must not receive any payment from any UK source in relation to their visit, whether that happens prior to, during, or after the visit, other than reimbursement for their reasonable expenses such as accommodation, travel expenses. The maximum period of a visit to the UK is 6 months. And in addition, the maximum period that a visitor can spend in the UK in any rolling 12-month period is 180 days over that rolling 12-month period. EU nationals currently are on the list of non-visa nationals for the UK, and that means that they can continue to use their passports to enter the UK without requiring a visit visa in advance of travel as a general visitor. However, this does not preclude them from applying for a visit visa if they feel that it would be convenient and would facilitate their travel, particularly where there's frequent travel into the UK. The general permitted activities as a visitor include attending meetings, conferences, seminars and interviews, giving speeches, negotiating and signing deals or contracts, promoting work, attending trade fairs, site visits and inspections, gathering information for employment overseas, and being briefed on the requirements of a UK customer for work to be conducted outside the UK. Intra-company activities which are permitted include where an employee of an overseas-based company is coming into the UK to advise, consult, troubleshoot, provide training, or share skills and knowledge, or to work on a specific internal project with their UK counterparts within the same corporate group as their overseas employer, and they won't be carrying out work directly with clients. Just note that there are expectations that the duration of a visit will be limited here and won't last the full 6-month period. In addition, it is possible for an internal auditor to conduct regulatory or financial audits at a UK branch within the same group of their employer overseas. Key elements and information to bear in mind when visiting in the UK is that, as I just mentioned, EA and Swiss nationals can visit for short trips without needing a visa. They can use the e-gates if they're open, but they should be prepared to answer questions at the UK border. Passports must be valid for the entire visit, and we also recommend that they're valid for at least a couple of months after the end of the visit. Most individuals will not be able to use their national ID card to enter the UK from the 1st of October 2021. Therefore, it will become increasingly important to ensure that EA nationals have a valid passport, and if they don't, they're applying for one now. EA nationals coming to the UK as a visitor should travel with all of the relevant documentation, and that should evidence the purpose and duration of their visit, funds available, their job overseas, and their intention to leave the UK, and not just a return flight booking. For those who hold EU pre-settled or settled status, a frontier worker permit, an S2 healthcare visitor visa or permit, and Swiss service providers, they can use their national ID card to enter the UK until at least the 31st of December 2025. In these times of the coronavirus pandemic, it's even more important to check the UK's latest pre-departure and post-arrival testing, documentary and self-isolation requirements. These are changing frequently, and I've provided a link with the slides to verify this information. That's the end of my presentation today. I hope you've enjoyed it and found it useful. I'd be delighted to hear from you with any questions, and we'll provide the slides for you to review. We'd be delighted if you could join us for the panel session with Natasha Chell, partner at Laura Devine Immigration, Smriti Jayanandan, senior solicitor at Laura Devine Immigration, and myself, Nicolette Bostock, Senior Solicitor at Laura Devine Immigration, discussing frequent questions that we receive about the EUSS Frontier Worker Permit and the visitor category for your enjoyment. Thank you very much. Bye-bye.